Hi, thanks for joining us again. I'm Chief Legal Officer of Swift Law North, Jordan Isringhouse. I'm here with CEO of Swift Law North, Aaron Swift himself. Thanks for joining us, Aaron.
Thanks, Jordan.
All right, so today's topic, this video's topic, we're still on the ABCs of the FDCPA. Here we want to talk about statute of limitations, defenses, and potential counterclaims. So to start off with, at the top of that list, talking about statute of limitations, or SOL, as attorneys say for short. What is that just generally as a concept?
Yeah, great question. So SOL, or the statute of limitations, is the time period by which, after a certain conduct has happened, that you have to sue to successfully enforce those rights. So in short, said differently, it's a time limit that once the law is broken, that you have to sue by. So most statutes have them, most laws have them, and certainly the FDCPA does here.
Okay. So if you don't file your claim by the SOL, you might be SOL, right?
Is that why you're smirking already?
That's what I had that in mind, yeah. So for the FDCPA, what is the statute of limitations?
That's great, yes. So it's exactly 1 year. So violation happens, a letter is sent. Well, let me actually skip to another example. A call is placed, and on that call, there's some harassing and abusive language. The consumer has 1 year from that date to file. If it's 1 year, 1 day later, too bad, too sad. That consumer will not have the right to affirmatively file that case, or if they do, will lose. Very likely.
What if I, I'm the consumer and I didn't even know about that I had my right? Is it still too late if I'm outside 1 year?
That's a great question, and this issue has been litigated very heavily. So some very kind of specific scenarios. I'll give you one. So a debt collection letter is dated January 2nd of this year. That's the date it gets mailed out. It gets to the consumer on January 5th, and there's something wrong with that letter. Does the consumer have a year from January 2nd? That's when it was sent. Is that when the violation occurred, or is it from January 5th? And in that case, it's been held January 5th because the consumer didn't discover. It's called the discovery rule in short, and in some applications it can be used under the FDCPA. And it's really to deter bad conduct, because if you could get around it so easily as a debt collector, what if I date the letter January 2nd and I wait 6 months to send it? Did I just cut in half the consumer's time? Another similar issue is, what if a consumer is sued and within that lawsuit there are some violations, like the debt collector who's suing or the debt collection attorney is trying to get too much money? Well, is it from the date the lawsuit was filed, or is it the date the lawsuit was served? Because a consumer in most cases isn't going to know they're sued until they're served by way of a process server or certified mail. What if a debt collector files a lawsuit and then waits 6 months to serve the client? Again, those are limited circumstances where it could be a 1 year plus, but in a way it's not exactly 1 year plus. It's from the date the consumer discovers the issue, and usually it's exactly 1 year.
Okay, so let's say we have a courageous consumer that was the victim of some bad debt collection. It's a letter, it's a text message, whatever it is. Consumer finds an attorney files lawsuit on behalf of consumer against insert debt collector here. That debt collector probably has a lawyer, right? Okay, and so that when that debt collector's lawyer shows up in the lawsuit, what are some things that debt collection lawyer is probably going to say about that lawsuit? And obviously, they probably don't agree with it, but right. What might they say in response to it?
Yeah, so I think you're asking what are the common defenses, right? Yeah. So at this scenario, the consumer has sued, like you described, had an attorney like us at Swift Law North, and has filed this lawsuit against the debt collector, and they're going to file defenses in response to it. And there are some common ones that we need to keep in mind, and all of our audience members and scholars need to as well. The first is, we just talked about, the statute of limitations. Mm-hmm. Just be super careful that you have filed that lawsuit within a year, because that's the first thing they're going to look at as a defense is, can I assert that this case is untimely? Another one is, we go back to the foundation, go back all the way to the definitions and the principles of the things we've been talking about today in the ABC so far. Is, what are the definitions? Is it a consumer? It could be a defense to a lawsuit if it's an entity. Is it a consumer debt? Some common examples of things that are not consumer debts, like a toll or a parking ticket or child support. These are things that can be debt collected aggressively, even credit reported, but those won't count as consumer debts. So that could be a defense to that lawsuit, is we actually shouldn't even be here. And lastly is one called the bona fide error defense, or BFE. Any funny acronyms?
Nothing on that one. Nothing for our audience. Thank you.
Okay, understood. So the bona fide error defense means we may have committed this error, but we did so unintentionally. And I know we talked about strict liability before, but here's the kicker. If I can also prove that I have reasonable procedures in place tailored to avoid the specific violation at issue, and I followed those procedures. That's a tall task. That's raised in almost every defense to these cases. The debt collector is going to say, oh, I'm sorry I called at 10 p.m. I have this procedure and process in place and it shouldn't have happened. But they're going to have to prove that. And that actually shifts the burden to them to prove that instead of the consumer having to prove his or her case. But those are basically the three common defenses.
Okay, so with defenses, we have these kind of statements by a debt collector that says, here's why you don't win. As I understand it, a way to get even more aggressive on behalf of a debt collector would be to file a counterclaim and say,
Yes.
hey, consumer, pay up, right?
Yes.
So, talk me through that process a little bit.
Yeah, and that's one of the very important considerations that every consumer needs to think about, every affiliate partner who is connecting consumers to attorneys or to Swift Law North, and certainly our affiliate partners, is there a risk, and are we possibly going to make the consumer worse off by filing this lawsuit? So let's talk about that. I mentioned earlier in one of the videos that a secret of this type of, actually in a later video, a secret of this type of law is that even if you owe the debt, you can still violate, or a debt collector can violate your rights and you can still sue them. And again, sometimes consumers say, well, I owe it, so it doesn't matter what they do to me. But let's talk about the risk of being sued, because we talked about damages before. And if your damages are limited to $1,000, if it's not a super, egregious case or some sexy case with a lot of actual damages, well, if the consumer owes $5,000 and it's not past the statute of limitations in reverse, which means it's not past the time where the consumer can be sued for that debt, and that's usually by contract, 4 or 5 years sometimes, with credit cards, for example. What we don't want to do is invite that, because if they place a bad phone call, send a bad letter, and we sue and say, you are $1,000, but they come back and say, well, guess what? He owes us $5,000, so we'll take $4,000. That's a bad situation. And sometimes the filing of that lawsuit is the catalyst. You've kicked the hornet's nest and it invites that position. So we're going to go through an analysis, or your attorneys, the consumers, the affiliate partners need to, and say, is this money still owed? Is it past the statute of limitations? How much is it? As a standard practice, if it's around $1,000 or less, we certainly don't care, because then the lawsuit can be used as leverage to maybe get that debt, completely erased. But it is a great consideration, something we always have to think about in any of our consumer protection statutes, is we don't want to make the consumer worse. So we are very careful about making sure we file these lawsuits in a way that doesn't invite counterclaims, which could, again, put a consumer in a position where they're actually worse off than when they hired us.
Okay. Well, thanks, Aaron. You've taken us definitely through a lot of the defenses and the counterclaims, and more basics on our FDCPA. So thank you, and continue to watch this lecture series in relation to the FDCPA. Engage in our affiliate chats, and if you have any questions, reach out to Swift Law North, either CEO Aaron Swift or CLO Jordan Isringhouse. Thank you.
Thank you.